Heartiest congratulations to all the awardees. Now I would request the chief guest for today to deliver his note.
A very good evening. Justice A. Patnaik, former distinguished Judge of the Supreme Court of India, Justice Akhil Qureshi, former Chief Justice of the Rajasthan High Court, Judge of the Gujarat High Court, Ms. Anuradha, Dr. C.B.K. Mohanty, Mr. Rafiq Dada, Dr. Sushil Bajaj, Dr. Shilpi Shahu, distinguished senior counsel who are present in the audience, and all the invited guests. I thought that by definition I should be excluded from speaking this evening because I was quite surprised, and honestly happily surprised, to learn that I'm going to be the recipient of this award. I was not quite prepared for it because I was under the genuinely mistaken belief that I was to hand over the awards this evening. But honestly, as I was looking through the recipients of the award and the brochure, Justice Akhil Qureshi, Ms. Anuradha, Dr. Chinmay Mohanty, Rafiq Saab, Mr. Rafiq Dada, Dr. Sushil Bajaj, and Dr. Shilpi Shahu. What a distinguished galaxy of citizens have received this award today. It's just a reminder to all of us of the range, the depth, and the diversity of achievement in our society. I can't speak of all of them together because then that will consume the time that I have to deliver my lecture this evening. I can only mention about Mr. Rafiq Dada, who was my predecessor in office when I became Additional Solicitor General of India in 1998. As Shyam said, Rafiq Saab and I, all of us go a long way back in time. He really mentored all of us as young lawyers. Whether he was an opponent when he was amazingly fair, never took advantage of the seniority over our inexperience at the bar, or later, when it came to appearing before us, never condescending before us as young judges who were really mentored by him. He never looked down upon us, but always looked up to us because he realized that a judge represents a cause of an institution, the cause of justice. And of course, I would run into him every weekend at the CCI where he and his beautiful family, Shahnaz and the children, would be walking. I was pleasantly surprised to learn from him that he does his 3.5 kilometers even today. That shows the strength and the tenacity of the Bombay Bar. I'm truly delighted and honored to speak on the occasion of the birth anniversary of Justice B.R. Krishna Iyer. In many ways, Justice Krishna represents the indomitable spirit of India. The spirit which speaks truth to power, looks out for the underprivileged, gives voice to the voiceless, and is conscious of the social hierarchy and prejudice that even today permeate our society. Justice Krishna was a person of many hues. He carries and carried the rich legacy of being a member of the Legislative Assembly. Just a reminder that parliamentarians and legislators make amazing judges, a cabinet minister, a member of the law commission, a judge, and a social activist. Let me begin by just narrating a few of my own personal engagements with Justice Krishna Iyer. In 1999, when I was working as ASG, there was a conference of the Bar Council of Maharashtra and Goa in Aurangabad, where Justice Krishna Iyer was invited as the chief guest. I was asked to speak, and I still had that impetuosity of a young lawyer. And I thought I should preface my comments that evening by saying that it was time that we revise the service conditions of judges. God alone knows what prompted me to say that. After I concluded, Justice Krishna Iyer got up and decided to speak. He says, please remember Mr. ASG, that when you accept judgeship, you accept judgeship oblivious of the conditions of service and not for the condition of service. Later that evening, after we had dinner, Justice Krishna held my hand and said, would you walk me up to my room, because his eyesight was failing. He said, I need someone to put eye drops in my eyes. So I held his hand and walked him up to the room at the Rama International where we were staying and put those little eye drops. He said, well, you'll have to wait for a while until I settle down. And for the next 20 minutes or 25 minutes that I was by his bedside, sitting on the bed by his feet, he unfolded some of the most brilliant ideas about penal philosophy, about his judicial career, and what the law and society mean to him. In 2004, on the occasion of the 60th wedding anniversary of my parents, who were married in 1944, I invited Justice Krishna here to come and join us for the event, a little dinner which we had hosted for my parents. He came to Mumbai specially. He took a cab from the airport, those ubiquitous Kalapila cabs as we call them, came to our building, sent a word to the liftman upstairs and said, Justice Krishna is unable to walk up to, I think, the lift and come to the flat. But he says, I'm sitting in the cab. So my parents came down to the ground floor. He wished them. He said, I just took the flight from Cochin and now on my way back to Cochin. I came all the way just to see you. I think it was 2014 or 2015, which was when he was entering his 100th year. And he expressed a desire that I should be delivering a lecture in his honor in Cochin. And so I was invited to speak. He sat by my side. I was overwhelmed by the occasion of having to speak in front of a great man, but so very unassuming. And at the end of the lecture, unfolded his own vision and response to what I had said. Krishna, of course, was responsible for developing a whole new genre of legal language, words you would rarely find in the dictionary. Among the staff in the Supreme Court, there were people who had to be actually found to go and be in his office because everybody got scared when he started a dictation because the words which he used in his judgments were very difficult to come by in dictionaries. But then some of the senior judges of the Supreme Court once said this to me after they had retired, and they said, young man, don't get lost in the words of Krishna, because behind those words lies a profound thought, a message, a vision for a just society. So whether it was in the context of his judgment in Bangalore water supply, where he spoke about what industry means under Section 2J of the Industrial Disputes Act, and he unfolded a triple test. The question was whether Pantrapols, education institutions, clubs, universities, could these be regarded as industry? And there were judgments of the Supreme Court which said that how can an educational institution be an industry? How can a Pantrapol be industry? How can a hospital which tends to the needy be an industry? I'm sure, we have hospital administrators here as the recipients of the award, and I'm not sure how they look upon the judgment. But Justice Krishna's philosophy was, how is essentially the work which is carried on in a hospital distinct in terms of the relationship of labor and capital from any goods or service producing industry? Or in Jolly George Verghese, where he spoke about the fact that you can't imprison a debtor for the inability to pay a debt, because that would be fundamentally contrary to the principles underlying Article 21 of the Constitution. But all these, his titles, his achievements, they only tell you what Justice Krishna did. They don't tell you why he did what he did. Growing up in colonial India, Justice Krishna learned two things from his father. First, to think of the community around him. And second, to use the law for the benefit of those who needed it the most. His life is truly an embodiment of these principles. His courage and commitment to justice cannot be divorced from his understanding of the people of India and their marginalized citizens. And looking at the lives of these judges every day of my life as a Chief Justice and before that as a judge of the Supreme Court, the High Court, you're reminded every moment of your life that And there's this overwhelming sense of the past which works on your mind in the present, in your attempt to create a society for the future. There are 2001 ways you can find a technical solution to a human problem. But judges like Justice Krishna have constantly reminded us that to find technical solutions to deny a citizen justice doesn't subserve a just cause. And you have to find answers to seemingly intractable problems. His courage and commitment to justice cannot be divorced from his understanding of the people. When I was invited to deliver this lecture, I thought about the remarkable life that Justice Krishna lived and the topic that might befit his rich contributions to law and society. Naturally, his contributions cannot be summarized in a lecture. However, the theme of social justice and emancipation run through every stage of Justice Krishna's life. Justice Krishna contributed to the development of constitutional law, labor law, personal law and criminal law in India. One of his most important contributions is a strong commitment to reformative justice, which brims through his judgments and personal philosophy. In his book titled Access to Justice, A Case for Basic Change, Justice Krishna has said that the criminal law in India is not victim-oriented, and the suffering of the victim, often immeasurable, is entirely overlooked in misplaced sympathy for the criminal. Though our modern criminal law is designed to punish as well as reform the criminals, yet it overlooks the byproduct of crime, that is the victims. Reformative justice has championed the cause of victims like no other approach to criminal justice. It asks questions like, what is the harm? What was the impact of that harm? How can that harm be remedied? These questions require a response from the person who has been harmed before the process can move forward. The person who suffers the harm shapes the restorative conversation by defining the harm and the needs arising from that harm. Our attitude towards crime has been unfortunate. Crime in its most normative sense is a morally reprehensible act which is punishable by law. This sense of morality, however, is socially constructed. It's a social construct and allows the prejudices of our society to percolate into law. We can see examples of this throughout our legal history, from the criminalization of nomadic tribes and transgender persons under the Criminal Tribes Act of 1871 to anti-sodomy law and the adultery provisions under the Indian Penal Code, Section 497. These provisions trespassed over the dignity and autonomy of people under the name of a criminal statute. Reformative justice allows us to reimagine the possibilities of a society where we retain our humanity and that of a person who has committed a crime. At its core, it is based or built upon informality and flexibility, offering a compelling alternative to our traditional criminal justice administration. As a very distinguished scholar, Linda Radzik has suggested in 2007, adopting a restorative justice paradigm allows us to establish a moral advantage over the conventional criminal justice system. It acknowledges that the wrongdoers possess moral responsibilities, affirming their status as agents and as not mere objects of the administration of criminal justice. This is fundamental to treating them with the respect that all humans inherently deserve. Although it is crucial to integrate restorative justice into our legal system, the real challenge emerges after offenders are released, as they struggle to reintegrate into society. Offenders often lack self-respect, economic opportunities, and face the social stigma of imprisonment, increasing the risk of recidivism. One example of this is the fact that there are express rules and regulations denying government jobs to those who have been previously convicted for a crime. Some of these rules even deny opportunities to those who are undergoing trial. So we pervert the presumption of innocence even at the stage of trial. Such is the tragedy of our prejudice against criminals, and I say criminals in inverted commas, that in effect we penalize innocent citizens who are under trials and convicted felons who have paid their dues under the law. This reminds me of a poignant moment from the movie The Shawshank Redemption, where a character, Brooks Hatlin, is released from prison after spending 5 decades behind the bar. Despite his freedom, he finds himself overwhelmed by the outside world, unable to cope with the changes and feeling like a stranger in a society that has moved on without him. Imagine somebody who was incarcerated in 1970. That person would be a completely different person today in a new society that we look at today. Like Brooks, many released prisoners face an uphill battle when they attempt to reintegrate into a world that has transformed during their time in confinement. The current punitive model, with its emphasis on punishment rather than rehabilitation, fails to address often the complex needs of these individuals. Restorative justice, with its focus on reformation and reintegration, offers a more promising approach to help these individuals regain their place in society and become contributing members once again. By addressing the root causes of criminal behavior and offering support for rehabilitation, we can pave the way for a more just and inclusive society. In this context, it is essential that we shift our perspective from solely focusing on the past actions of today's convicts to prioritizing their future and reformation. This future-oriented approach is at the heart of restorative justice. We have 2 methods to respond to crime. One is to maintain a hostile attitude towards the offender, punish them, and stigmatize them even when they are released, while the other recognizes the social and individual breakdown that may have contributed to the offense and seeks to rebuild lives for a better future. The former is simply the old wine of retribution in a new bottle, while the latter, restorative justice, is a genuine and reformative approach. Another distinguished scholar, Albert English, describes justice as the first mile, involving punishment or reparations, but this does not fully redeem the situation. The second mile of justice, represented by restorative justice, encompasses a complete restoration of goodwill and harmony in society. Restorative justice encourages offenders to empathize with the victims, make amends, and embark on comprehensive rehabilitation, emphasizing personal freedom and social recognition. It invites them to become contributing members of society, fostering a sense of redemption, crucial for lasting change. For those of you who have read a fascinating book called The Strange Alchemy of Law and Life, deals with a judge of the Constitutional Court of South Africa, who was a member of the African National Congress. When he started his car one day, a bomb was placed under the car and blew the car up. He lost his entire right hand in the bomb blast. Later on, he says in his book, when he went to a bar as a judge of the South African Constitutional Court, someone came up to him and said, "A young man wants to meet you, sir." So he said, I walked up to the bar and said, "Let me say hello to see who wants to meet me." And wonder of wonders, a person comes and shakes his hand and says, "I was the person who put the bomb under the car which blew your arm off. And I've just come to say I'm sorry for what I did." Of course, in South Africa, they had the Truth and Reconciliation Commission, where people who were offenders came to the fore, confessed to their crimes, were forgiven, and society, hopefully, has sought to move forward. Justice Krishna Iyer was far ahead of his time in espousing these techniques and verbalizing them in his judicial thought. The profound influence of his formative years shaped the dawn of civil liberties that we know today. As a young advocate in Malabar, Krishna Iyer protested against police torture during interrogations. Consequently, Justice Krishna Iyer, then Krishna Iyer, was imprisoned for a month. He was imprisoned for a month on a fabricated charge of providing legal assistance to communists. Those experiences shaped Justice Krishna Iyer's understanding of bail, the imprisonment of under trials, and victim compensation. He truly believed that the issue of bail is one of liberty, justice, and public safety, all of which require a developed jurisprudence of and a socially sensitized judicial process. In the state of Rajasthan versus Balchan in 1977, Krishna Iyer edged his judicial philosophy in India's law on bail by declaring that bail is the rule and jail is the exception. On the same lines, Justice Krishna Iyer believed in the humanity which inheres in all people and believed parole to be a surety to the reformation of a convict. In Ratan Singh versus State of Punjab in 1980, he allowed prisoners temporary release and demonstrated a commitment to facilitating their social reformation and redemption. One can identify the constitutional beginnings of victimology in Justice Krishna Iyer's perspective. Victimology, in the context of restorative justice, is the study of the experiences, needs, and rights of victims within the criminal justice system. This field delves into understanding how the justice system can better respond to the needs of victims, fostering a more inclusive and compassionate approach. A renowned scholar, in a book titled Critical Issues of Victimology, has passionately argued for a victim-centered approach, emphasizing that the justice system should prioritize the rights and well-being of victims above all else. On the other hand, another scholar has advocated for a more balanced perspective, arguing that restorative justice should seek a fair reconciliation of the interests between victims and offenders. He contends that while victims' rights and needs are crucial, a restorative framework should also consider the rights and potential for rehabilitation of offenders. This brings into focus another element of restorative justice, namely victim compensation, for which we have provisions in our own Code of Criminal Procedure of 1973. The Supreme Court has been instrumental in introducing victim compensation into Indian criminal law from the time